Now, the Supreme Court has reaffirmed the death sentence that was handed to Maryam Sanda, the daughter-in-law of a former chairman of the People's Democratic Party, PDP, for committing culpable homicide. In a split judgment of 4-1, a 5-member panel of justices of the Apex Court restated the judicial pronouncement that ordered her death by hanging. The court resolved all issues she raised to set aside her conviction and the sentence against her and dismissed her appeal for want of merit. In the lead verdict that was delivered by Justice Moore Adumein, the Apex Court held that the prosecution established her guilt beyond a reasonable doubt. It held that the Court of Appeal's decision that upheld the sentence that was passed by the trial court was unassailable. The Supreme Court held that it was wrong for President Tinubu, being the head of the executive arm of the government, to seek to exercise his powers to grant a pardon over a case of culpable homicide, in respect of which an appeal was pending. Now, joining us via Zoom to shed light on the Supreme Court judgment is a senior advocate of Nigeria, Sam Kago. Good evening, and thank you for joining us this evening.
Good evening, and thank you for having me this evening.
Thank you. All right, let's jump right in. Now, on the Supreme Court's final decision, the court reaffirmed the death sentence and said the evidence proved Maryam Sanda's guilt beyond reasonable doubt. Now, in simple terms, just for our viewers to understand, what made the court so convinced that the earlier judgments given to her were solid?
Obviously, the evidence before it, because what you take to the Supreme Court is basically what was in issue at the Court of Appeal. And if from your case as presented by you in your own appeal processes, you are not able to convince the court that the concurrent finding of the trial court and that of the Court of Appeal were wrong, definitely the Supreme Court would upheld.
All right, our guest is back on, and Sam Kago, a senior advocate of Nigeria. Thank you for joining us back.
I'm sorry for that hiccup. It happened.
All right, so I will take my first question again for clarity's sake. Now, on the Supreme Court's final decision, we saw that the court has reaffirmed the death sentence and said the evidence proved Maryam Sanda's guilt beyond reasonable doubt. So in simple terms, what made the court so convinced that the earlier judgments were solid?
It's basically the processes before it. Because what really happens on appeal is a rehearing of the case as it was presented at the Court of Appeal. So if the appellant, in this case, Maryam Sanda, was unable to convince the court that the Court of Appeal was wrong, or that the concurrent findings of the trial court and that of the Court of Appeal were wrong, then obviously the Supreme Court would upheld the judgment of the Court of Appeal as it has done. So, variably, in simple terms, it failed. The appeal failed.
According to the reports, we saw a 4-1 split, that is among the justices. So for viewers who may not understand, what does a split decision like this usually tell us about the complexities of a case?
Well, for us lawyers, that's very normal. Usually you would have one or two dissenting opinions, and it happens. But since they are in the minority, in this case, 1 out of 5, we lawyers discountenance entirely that opinion because it's in the minority. What counts as judgment and what is binding is the judgment of the majority. Basically, the dissenting judgment would have seen some aspect of the case that it felt, or that he or she felt was favorable to the appellant. But beyond that, that's all. That is its value. What stands and what is reckoned is that of the decision of the majority. That stands at the judgment of the court. You cannot at any point even refer to the dissenting judgment because it's of no judicial value.
All right. The Supreme Court made it clear that President Tinubu could not even consider a pardon while Maryam Sanda's appeal was still active. And when you look at under the Nigerian Constitution, the president's power to grant pardons only applies after all court processes have been completed. So help us understand this better. Why exactly does the executive arm have no legal space to step into a homicide case that is still going through the court? And what constitutional risks could arise, that is, if a president intervenes before a final judgment, excuse me?
Well, let me start by saying that I have my suspicion that that statement, if it indeed was made by the Supreme Court, it was just an opinion off record, because obviously that issue would not have been an issue before the court. The fact that judgment was actually made means that all processes had been put before the pardon. And obviously, that issue could just come to the court as information. But beyond that, what matters is what was at issue, what was the dispute between the parties before the Supreme Court. That is what forms the judgment of the court. Opinions as to whether or not the pardon was right or wrong, in law, we call that an obiter. Yes, they are part of the society, and usually when an information of that nature is passed to them, they have every right to express their own opinion, but that will not affect the judgment as they have passed. But let me look at it again this way. The executive pardon is independent of the judicial process. The judicial process goes on its own, because the Supreme Court is the court of finality. And what it has done with its own judgment, it has put a finality to the issue of whether or not Maryam was what? Guilty. And that finding that the trial court made and the Court of Appeal affirmed was put to rest, or given a final signature by the judgment of the Supreme Court. So what that one means is that as of today, Maryam is guilty and the death sentence enough. But whether or not the pardon would be affected, I'm not too sure that it will be affected, because that's independent of that. Yes, if the position of the Supreme Court is that the pardon was unlawful because there was an ongoing process, that's something besides the point, because that issue couldn't have been argued before them as to whether or not the pardon was lawful, because that was not an issue at the Court of Appeal. And mind you, the Supreme Court's business is a rehearing of the case as it was exactly at this Court of Appeal. Nothing less, nothing more. If there is any issue that needs to be added, there has to be an application to that effect to bring in a new issue. And if that was done, fine. But if that was not done, the passing statement to me is of no moment. And in any case, to me, even if the pardon was done during the continuation of the process, who was before the court? It was Sanda herself who was trying to get vindicated, or to have the concurrent findings of the the trial court and the Court of Appeal overturned by the Supreme Court. And in that case, besides the point that the court will feel offended that there is some form of contempt that the case was already before it and the executive went ahead to dabble with it in the manner it has done, which is to say that the executive was contemptuous of it. Beyond that, there was no prejudice to the what do you call it now, the prosecution at all, because it has done its point, it has been vindicated, it has won at all levels of the trial, the Court of Appeal, and the Supreme Court. It's done its own part. And if you ask me, I do not think, with due respect to the Supreme Court, that that statement would affect the pardon and the committal of Sanda's, what they call it, death sentence to a prison term. I do not think that it should be affected at all.
All right, looking at the reactions and criticism of this case, a lot of Nigerians still feel the Maryam Sanda trial was influenced by emotion and public pressure, especially because the case involved a well-known family and, you know, it got heavy media attention. But the case went through the High Court, the Court of Appeal, and even the Supreme Court, and all three courts upheld this conviction. So from your perspective, based on the fact and the multiple rulings, would you say she got a fair trial? And how do courts protect themselves from public pressure in high-profile cases like this?
Trust me, the courts are immune and insulated. Places we are different from the jurisdictions that have jury trials, where the jurors are the ones to make determinations on finding of facts. In those cases, yes, there is always the fear that media blazes, media attention, media slants, and narratives could influence the jurors. And that's why the jurors are usually secluded during the entire tenor of the trials, so that they don't get influenced by media blaze and media trial. But in this case, you have judges whose sole business is the law, the people who are canvassing the facts and making submissions regarding the facts are the parties themselves. And I do not think in any case, for whatever reason, any of the parties there was prejudiced by media attention. In any case, both parties, both the family of the victim and that of the what would you call it now, the murderer, since that's what all the courts have said, all of them are big people, and I do not see any reason why that should even be an issue, because in the trials, by our own jurisprudence, when I mean by our own jurisprudence, by our own, I will call it this time around, adjectival or legal principle, all trials must be in public. It must be open to the public, and it is mandatory for the courts to ensure that it is mandatory that all trials are in public, and everybody should have the opportunity of witnessing the trials. It is because our courts are small. Some other jurisdictions, as long as the matter is high profile, because when it's high profile, it instigates attention from all corners of the world and from all people. And so usually to help people, what would they call it now? Bring in the media themselves, so that people in their homes could watch the trial and make up their own decision. Because, mind you, justice should not only be done, but it must be seen to be done by the public. So that's why trials are always what? Three ways. The parties before the court, and the public. All of them must and should be carried along, and their own opinions, they are entitled to their own opinions, but their own opinions should not and would not affect the trials. The only time that the courts are protected are from what? adverse commentaries that tend to impinge on the integrity of the court. That's why you have the principles of sub judice. There is a limit to which you can urge attention or urge narratives to the parties or to the court during the trials, because that in itself would undermine the authority and the integrity of the court.
Thank you, Senior Advocate of Nigeria, Sam Kago, for speaking with us. Thank you.